Yeah, sure. So I had worked for the company for just over 10 years. My redundancy happened throughout the first COVID lockdown. So the part-time staff had not been given computer kits to work from home like the full-time staff had been offered. So we'd all had reduced pay and we were kind of at home. And we'd been at home since the March 2020. And I got a call literally out of the blue on June the 10th in 2020 from my manager, telling me that the company was not in the greatest of positions. As such, they'd had to look at different alternatives. And he asked me if I would be willing to enter into a protected conversation. I didn't have a clue what a protected conversation was at that time. He kind of outlined a little bit about it, but I didn't realise the implications if I got to a tribunal of the fact that obviously none of that information could be admissible. And he basically told me that the company had wanted to cut 16 hours from the administration department, which was what I worked in. They'd come up with a criteria, they'd done a scoring matrix. I was the least performing member of staff in the administration department, and I could either take £1,000 and take voluntary redundancy and sign obviously the paperwork that came with that, or if I wanted to refuse that offer, then what would happen would be that we would go through a consultation, but prior indications had showed that I was at the bottom of the scoring, and it kind of came across to me that the outcome was going to be inevitable, really. So I declined the voluntary redundancy because obviously it was, say, June 2020, we were just coming out the first lockdown. It was the worst possible time to not have a job. My partner's self-employed, so it was going to be the only reliable income that we had coming in. Lots of reasons. So my manager, who was leading the consultation and the redundancy, said that he would act as a kind of go-between, and he would conduct a consultation between the administration staff. My consultation lasted 11 days, and that included 2 weekends. So 7 days all in. I was spoken to twice about it. During that time, I raised issues with the criteria. I raised issues with the fairness of the fact that I was part-time. I raised issues with the fact that, other things hadn't been maybe taken into consideration, i.e. had everybody been offered voluntary redundancy, because I've been told to keep it confidential during the protected conversation and that I couldn't speak to anybody about it. And I kind of was putting all these things through, and I was saying, what about if I cut my hours? What about reduced pay? What about job sharing? What about furlough? Because the furlough was available. And they said that they'd taken a moral decision not to use the furlough scheme. even though it gets better, because even though they did draw 1.6 million on it to pay their contractors, they said that they were not prepared to use it for their own staff.
My goodness.
So every suggestion I put forward, he kept saying, yeah, I'm going to tell the other girls about it, and I'm going to tell, and we're going to discuss it, and I'm going to come back to you. And the upshot of that was I received a call, say just over a week later, to say that we've looked at the alternatives. The company put a clause in place that in order to change the criteria, it had to be a majority vote. So the majority of us had to want to change something in order for it to be considered, right. Which obviously was unfair. And yeah, I just got a call basically to say there are no alternatives, nothing you've suggested is viable. Thanks very much for your 10 years service, and that's us done.
Oh my goodness. Oh my goodness. And at that point, how did you get from, okay, I've done everything that I could, and I've still been made redundant in this awful time to be made redundant. How did you get from there to I'm going to do something about it? And how long did that take?
So immediately I raised a grievance. I sent a grievance appeal to the company, and I also sent a subject access request because I'd been given very little information. I'd initially received an email from the managing director because it got passed to him because the manager had been involved in the process. And he said, yeah, no problem. You know, we're going to get this subject access request sent out for you. You know, we're going to do that. We can have the appeal hearing, you know, you can have it with me. And I believe it was around 2 weeks later, I had my grievance appeal hearing. And basically, I think what they were hoping to do was just to kind of breeze over what had happened. I was told in that grievance appeal hearing that they'd already sought legal advice from their legal team. They knew they could easily win a tribunal. The tribunal had no jurisdiction on how to tell them to run their business because it was their business and they run it how they see fit. Basically, I was asked for an apology for bringing, you know, when you've in the cold light of day, we'd like an apology for you bringing these accusations to us. But the thing that really made me suspicious was that at the beginning of the call, we agreed to record it. And so he said, can I record it? And I said, yeah, that's fine. And then he rang me a few days later to say, I'm not upholding your appeal. Basically, we did everything right. We don't see there's any problem. And just to let you know that the call recording didn't turn out because my IT skills let me down. And I thought, this is just getting really odd. By that point, they were trying to charge me £250 admin fee to do the subject access requests as well.
Oh, okay. And can you just clarify for people who don't know about subject access requests, why that's unreasonable?
So unless a request is excessive or manifestly unfounded, they do not have the right, an employer or anybody can't charge you for information held about you. And I think at the time, if they could, I think the cap was about £10, something like that.
I think they can now ask for a very small amount of money for very, you know, like large requests or things like that. But
yeah.
250 is, that's
yeah, and plus transcription costs, because all of my consultation was done over the phone, and I knew they'd recorded that, and I said I wanted those call recordings, and they said, well, we're not giving you the recordings because it contains the manager's voice and he doesn't want you to have it, so you'll have to pay for transcriptions, which I found out later are vastly expensive. And so really it was just an accumulation of things that I just thought something's just not right to me, and that's kind of what made me think I'm going to take it further.
Now, Lisa, where did you, I'm so pleased that you immediately filed a grievance and that you also did the subject access request. How did you know to do those things? What resources were you using, or was this something that you had learned as part of your job or something like that?
So the grievance appeal was in the handbook, which luckily, just purely by chance, I had an emailed copy of. We'd been sent an email with the handbook, so I knew to do that. The subject access request was purely through searching online, because I knew that I needed to get my hands on the call recordings, and I didn't know how to go about it, and I knew that they certainly weren't going to give me them to be nice.
Exactly, yeah.
So I think I just came across like the ICO website. I think I started looking for how I could get my personal data, and we'd done a little bit about GDPR because I work for a payroll company and we hold people's details, so we'd all kind of done courses and things on that. So I knew that I was entitled to it, but I didn't know about how to get it.
Okay, that's brilliant. And for anyone else who's listening who hasn't heard about subject access requests before, we have a free module and template for the subject access request on the Vala platform. So if you log into Vala And then you look in the template section, you will see it's called Data Subject Access Request, DSAR. And if you click on the before you start, you'll find a video course that explains when you can use a subject access request, what you can ask for, lots of stuff like that. So if there's anybody more interested in that, that's where I would look first, if that's helpful. Okay, so let's fast forward then. Talk to me about how you started to formulate your claim and understand, okay, this was clearly wrong. Like you had that like, okay, something's very off here. Talk me through how you went from something is very off to I am going to make a claim for X. How did that work?
So I rung ACAS a couple of times because again, I think they're kind of the first port of call for everybody. And they kind of said that, again, if they don't, because at that time, trying to get to speak to somebody, they were just overrun with calls, and they were pretty much directing everybody to the website, I think. And I spoke to an advisor, and one advisor told me that I must have got it wrong because the company just couldn't do that. And so I must have got it wrong. And I said, well, no, I've definitely not got it wrong. And so I really, I mean, when I say that my entire claim was just sponsored by Google, it literally was. So yeah, I went on the ACAS website, started to do a little bit of research into what it came under, and the process as well, that you had to register with ACAS because you needed the certificate number, etc., etc. I'd come across on the internet, or I think it could have been ACAS that said to me about the legal cover on my insurance. Was I part of a union, which no, I wasn't. Did I have any legal cover on my insurance, which I rung them and they said no, unfortunately I didn't. So it was kind of it was kind of a decision of I either walk away or I'm going to need to go through this on my own. So yeah, I just felt that I just couldn't close the door on it. I just felt I would always have wished that I would have taken it further.
Yeah, and so that's when you made the choice. I take it you phoned up a law firm, found out how much it would cost?
Yeah, phoned several. Did get like a half an hour free consultation, I think, with somebody, but they came back and said that they weren't prepared to offer me no win, no fee, but kindly I could pay them on an hourly basis. And it was, I think, £400 an hour plus VAT, something like that. I did get offered one no win, no fee, but one of the clauses in the contract was that if the company didn't pay, if I was successful and the company didn't pay, that I would have to pay to take them to court to retrieve that money. And because of the past history of the company, I knew that they had an ongoing appeal for an exceptional amount of money. And it was just a risk I just couldn't take. I genuinely didn't think that even if I was successful that I would see a penny from them, because I did genuinely think they would appeal it. So I just financially couldn't afford to take the risk of the no win, no fee.
That makes sense. And so at that point you said, I'm going to do this myself. And at that point, that meant you were saying, okay, I'm going to file my tribunal claim document. It sounds like that was also sponsored by Google. Is that right?
It was. Yeah. And and I mean that in itself, I mean, I think the thing with the tribunal process is you do literally like hit the ground running, and it's literally like from that very first click of that button, you know, you click onto that form, and if you don't include all of your claims that you bring in, if you don't include individual names of people as well as the company, if you don't include vital information, straight away you're kind of setting yourself an even bigger task, because potentially you may have to get that added at a later date, but obviously you don't know that at the time. And my ET1 was pure, I've said this so many times, pure luck and judgment, that I managed to get it somewhat in some sort of order and be able to kind of pursue it.
That's Yeah, we see that a lot. Well, so often people will find us before they submit their ET1, and then we can kind of help them using the templates and the peace of mind checks and stuff to formulate their claim. And sometimes we encounter people after they've done their ET1, and then we're advising them on using applications to amend, for example,
Yeah.
to add in claims or remove claims. So where did you end up in terms of the actual claim? Was it what were the actual legal claims that you went to tribunal with?
So the legal claims were initially unfair dismissal,
Mhm.
and then because there was a part-time element to the claim, it was also the part-time worker regulation
Mhm.
and indirect discrimination.
Okay. And just to fast forward all the way to the end, which of did all three claims win? How did it end up at the end with those claims?
The end was because of a protected conversation and without prejudice material, the respondent wanted the claim split into two.
Mhm.
So we had in effect to prepare for like two hearings. So yeah, so we had to prepare for the first hearing with one bundle and one witness statement, which was the unfair dismissal.
Mhm.
And then we prepared for the second hearing, which was going to include the protected conversation and the without prejudice. And that was going to be the indirect discrimination and the part-time worker regulation. The unfair dismissal was heard first, and that got a successful judgment.
Mhm.
The part-time worker regulation, we'd kind of already established that there was a 16-hour part-time element to it. So to go forward with the part-time worker one would probably have been in vain, really.
Mhm.
The indirect discrimination one, which is on one of my mistakes, is that I understood that because the claim was split into two, we were answering questions about the unfair dismissal first, and we'd then be answering questions about the rest the following week.
Mhm.
But the solicitor, as they do, kind of bombarding you with questions. I thought we were talking about one thing, which was the handbook. He was talking apparently about something else. And at the end of the hearing, I was told that because of an answer that I'd given during the proceedings, I couldn't have my discrimination case heard.
Wow.
I'm still not quite sure, to be honest, what happened.
Yeah.
Um, and yeah, but to be fair, when I got the successful judgment for the unfair dismissal, I was literally just so exhausted with the whole thing. And I'd kind of proven, and I knew I had a case, and they knew what they'd done, and I knew what they'd done. And I felt there was probably little to be achieved to appeal the decision.
Mhm.
So the second part of my claim didn't even get heard.
That makes sense. And I want to talk a little bit more about this without prejudice conversation. So as you mentioned earlier, for anybody who doesn't know about this, if your employer wants to, usually it's used for an offer like Lisa got. So if your employer wants to exit you from the company, they will ask if they can enter into a protected or without prejudice conversation. Now, often they'll send you a letter that says without prejudice at the top. You can send those too, by the way, and we can talk about that later if we want to. And it will say, we would like to exit you from the company, either by redundancy or for some other reason. Here's an offer. Now, without prejudice is kind of legal for this is protected from being entered into the tribunal if a tribunal happens later. So the general idea being, if they offered a lot of money, and later on Lisa might be been able to say, well, they offered me this much money already, so I think that should be the amount that I'm looking for. So that's the idea of this. Yours is the first case where I've heard that it sounds like that protected conversation really threw a spanner in the works for you later on. And can you just give a little bit more detail about how that impacted on your case?
Yeah, so we had to have a preliminary hearing, which involved, again, bundles and witness statements, to determine whether the conversation that took place was a protected conversation, and whether the correspondence that followed was without prejudice. And as you will know, Danae, a protected conversation is just inadmissible in unfair dismissal, but sometimes can be heard in other claims. Without prejudice is a no on all levels, unless you can prove that it wasn't actually without prejudice, or it would have some detrimental impact on your case if it was missed out. And that's what the judge ruled, that she felt that the company had used the without prejudice rule as a guise to basically cover up what they were doing. And she said that for the discrimination element and the part-time worker element, she felt that that she couldn't stop me from using it. But as I say, sadly, I didn't get the opportunity to. But yeah, they can be really messy. And again, like with anything, your employer does have a duty to explain to you what you're entering into. I think really you should be given notice as well. I mean, I was literally just rang up out of the blue and, will you enter into this conversation? And at no point did they say, that I wouldn't be able to use it or it was inadmissible. And I agreed. And obviously, once you're into the conversation, there's nothing you can do about it.
Yeah, that's a really important lesson to hear. So if you're in some of the earlier stages of your case, I mean, we have 70 people here. If you're in the earlier stages and your employer phones you up and asks for a without prejudice conversation, or if you feel blindsided by your employer in any situation, you're allowed to say, I need to take some time, let me come back to you, and then go and Google it.
Absolutely. Absolutely. Thank goodness for Google.
Yeah. So that's really useful to hear, Lisa. So okay, I'm so conscious that I have so many questions to ask you. Let's talk about, so we've kind of talked about the beginning and the end now, right? So talk me through, what did you learn? Like, how did you do this? How did you run your own case? Is there anything that you think other people might benefit from hearing about how you did it? And is there anything that you would change if you could do it again? Hopefully you'll never have to do it again.
Yeah. So yeah, I mean, when I started thinking about this, and certainly mistakes that I made, I've got a huge list, but I'll pick the main ones. So the first one, I think, the very first mistake that I made was that I trusted my employer, and I put my trust in someone else. And what I should have done was take responsibility, research it, like you say, ask for more time, because if your employer, like my former employer, has a predetermined outcome in mind, they're only going to guide you and help you in as much that they achieve that aim. And so, yeah, and whether it's a redundancy process or whether it's just the employment tribunal process, the best advice I could give is, take responsibility, do your research. Forewarned is definitely forearmed in this situation. So that was the first thing. Secondly, mistake-wise, I assume that the deadlines in case management orders and process were deadlines. I assume came to realise they were guidelines really than anything else. And I wasted so much time in trying to keep everything on track and research kind of implications for the respondent because they didn't meet these guidelines. And actually, on every occasion, the tribunal just passed extension after extension after extension. So yeah, it's a bit of a common tactic, I think, that one, definitely. Another one that I just didn't even think about before I started the process was the practical side of things. So I literally had a mobile phone at the time. When it came to sending over the call recordings to the respondent or to the tribunal, I had no clue how to do it. I had 300 pages of documents for the bundle to scan over, and I did it on my little HP printer one at a time. Just scanning literally one document after one document, and things. So definitely think about, you know, the practical side of things, you know, in advance, how you're going to get that information across, how you're going to download information that they send to you. You know, everybody kind of thinks that that dealing with the judge and things is the worst bit about a tribunal, but actually there's so many other things like off the back of that. That the solicitor wanted things in Word format. I could only send things in PDF. I couldn't convert them. It was, and because I didn't realise it and I left it to the day I was doing it, I was then in complete panic trying to register for WeTransfer files and things like that to kind of send, you know, to send things across. So yeah, that was that was a huge mistake. And I think just the wider implications as well. Again, you know, we talk about the process and we talk about the paperwork and the box ticking and the form filling, but what a lot of people don't understand is the other implications that this process has. So the mental implications, the emotional implications, physical implications, the implications on your family, and how it's hard to juggle that alongside the paperwork, and which is tedious and relentless in itself. I didn't even consider it when I started. But again, the important thing I think to remember is that we all make mistakes. It's the mistakes that we learn from. It's the mistakes that make you stronger. And there's always help out there. There wasn't anything that I came across that Google couldn't help me with in one way or another. You know, that there's forum sites, there's places like you guys, you know, there's the government websites, you know, and on a wider kind of scale, you know, I was very lucky because I had really good support around me with my partner and my family. But at stages, you know, I had to look wider than that, you know, and I went to my GP, and, you know, there's so much help out there. Don't be afraid of taking it, you know, because it's all of those things cumulatively that are going to get you through this process.
That's so beautifully put as well, Lisa. And I think, yeah, those lessons learned, as you say, you can make mistakes along the way. You're a living example. You can make mistakes along the way and still win at the end. So one thing that we were talking about before everyone joined. So what happens after the tribunal says, okay, we agree with you, that was illegal, you've won your claim? What happens next?
So in my case, the judge asked the respondent solicitor if they would like to enter into, again, a confidential conversation with me to see if we could come to some sort of remedy between us. And he asked me if I'd be willing to do that. I had absolutely no clue that that was going to happen. It was something I didn't even know existed. And I agreed because I didn't really know what else to do. And yeah, we kind of, because mine was over CVP, so it was a video hearing, and we kind of logged off, and then their solicitor rung me and obviously said that again, it was going to be a without prejudice conversation, so it wouldn't be able to be referred to if we needed to go back in front of the judge.
And did you agree in that conversation, or did you go back to a remedy hearing?
No, so what happened with that was that the respondent solicitor told me that they were going to make, the company wanted to make a full award to me because it had been obviously proven beyond absolute no doubt whatsoever that they were, and they wanted me to sign a COT3 form to pay me that money. And he said the reason that they wanted me to sign a COT 3 was because the company didn't want people knowing they'd paid me more than they had to. So, but and he was kind of going down this path that, you know, he said, oh, you know, you're the judge, you know, we'll give you that, you know, that the judgment will go on the website, but you know, you can't have reasons. And I think the final nail in the coffin with that one was that the company had told people that they weren't allowed to speak to me throughout the process. So I couldn't get any witnesses. People were deleting messages between us. That's another important point. Screenshot messages. If you've got messages from other people, screenshot them before they get a chance to delete them, because I didn't. And he said that if I signed the COT 3, they wouldn't write it in as a clause, but verbally they would agree to tell people that they were allowed to speak to me again if they wanted to. And I think at that point, I just kind of thought, you know what, you've had so much control over my life and everything else for such a long time that I really don't want to sign your form.
Yeah.
So you can kind of keep your form. And he said to me, well, is there a figure, you know, is there a figure that you know, you think is, you know, I'll go back to them. And I said, well, I really don't think, you know, because they also wanted me to drop the part-time worker regulation one, which I could have gone forward with. And basically they said, look, it's the basic award and you sign the COT 3 or we go in front of the judge. So I said, right, okay, then we'll just go in front of the judge and we'll go through mitigation of loss. And if I come out with nothing, I come out with nothing. That's not what I went there for.
Hearing, we have a tribunal coaching service. It's not on our website listed as a thing because we kind of haven't gotten that far yet. We're too busy actually doing the coaching. So if you email hello@vala.uk, if you want to inquire about the tribunal coaching service, I'll go ahead and give you the basic details. It's sold in 3-hour packages and it's £180 for 3 hours. And then we can do discounts at larger packages. And typically what we help people with at that point is case management agendas. So Tariq, you know, that kind of stage that you're at where you're saying, what is going to happen next and how do I prepare for it? And then once you get those case management orders, then understanding, okay, how do I do this? What's the next step? Helping people prepare for that preliminary hearing is a big part of what we do as well. And then the other thing that I just want to add is maybe Lisa will be able to join us, and I hope all of you can join us at this. We're doing another support group. So we had our first employment tribunal support group in December, and it was just before Christmas, and it was so popular. And so we're having our next one on the 1st of February. And the email invitation is actually going to go out, I think, tomorrow for the next Employment Tribunal Support Group. And it's going to be a webinar like this, except what we're going to do is break you into groups and we'll mix up the groups through the thing and you'll be able to help each other, talk to each other, and we will also be answering questions like we're doing tonight. And I believe, Lisa, you were at the first support group, weren't you?
I was, yeah, I was, and that's what prompted me to kind of, yeah, to put my story on to be featured on the website. And then lovely Meg obviously got in touch with me, and yeah, and I think as well, you know, the one, it's such a traumatic experience, to be honest, that I kind of felt that there had to be another reason for kind of going through everything that me and my family went through. And I think, you know, by helping others and supporting others and, you know, joining like the webinars and things like that, it's really kind of turned a bit negative into positive for me. And hearing people's stories, what they've been through, and just the sheer determination. I don't know what we all have, like the people who go through this process. I don't know what we have. I think if you could bottle it, it would be worth an absolute fortune. But we all have something, and that's something that just whatever point you get to in the journey, it's going to carry you through. And yeah, if I say, if you can share your experiences and help other people, and just say, you know, we've all kind of been on the kitchen floor crying, you know, we've all had those low points, but instead of feeling kind of bogged down under the weight of it, even if there's just a slight chink, I used to think more that I was lifting it rather than it was that was weighting me down. So yeah, I would definitely, yeah, love to be part of the one in February. I will put it on my calendar.
Awesome. It's going to be at, I believe it's 8 p.m. on February 1st. Meg, keep me right there if that's right in the chat. And you are all very welcome. It's free, just like this, and it's just there for you to all talk to each other, get support, ask questions. And before we wrap up tonight, I just want, Lisa, I'm going to copy these messages so that you'll be able to see. But can we all just give Lisa a virtual round of applause? Can we, you know, pop into the comments and just let her know, you know, people are saying, you know, you're so inspiring and you're giving other people the hope and the, you know, the courage to, and just the strength to kind of work through this. And so, yeah, I completely agree with Annie, legend. So
no, I think everybody's a legend. Everybody is a true warrior that goes through this process. And I say, don't ever forget to just take time and just give yourself the absolute credit that you deserve, because you're doing an amazing job.
I'm so excited that you're going to try to come to the support group so people can say hello to you and hopefully get into your group and talk to you personally. And everybody else, I will see you on the 1st of Feb if you can make it. And we will be running more amazing stories like Lisa's, and we'll be sending out this recording tomorrow. And then we're going to do a summary of Lisa's lessons learned on our blog as well. And if there's anything you need in terms of your tribunal and stuff, remember the basic VALA platform is free. So all those screenshots, all those documents, all those mean emails from the solicitors, you can record them there. You can put all those key dates in, Tariq, when they come through, so that you're not getting you know, overwhelmed with what's going on. So remember, the platform is free to use. It's only when you pay for a document or the coaching or things like that that you need to pay. Okay, Lisa, you have just blown us all away tonight. I cannot thank you enough. And congratulations again. And I hope we'll see you again soon. Thank you, everybody.
Definitely will. Thank you. Bye.
Bye, everybody. Thank you so much.